I'm Dr. And today we have the sixth webinar of our series, Houston, we have a solution. Now with Marieke, who is a Dutch judge and an independent arbitrator. Marieke is qualified in the Netherlands and in Texas, and she grew up next to the sea. That's why the topic of our webinar today will be Maritime Arbitration from Ship to Shore, where Houston meets global practice. So, Marieke, how did you end up in Houston?
For my husband's job. He works in oil and gas, and because of his job, I've lived and worked in Qatar, in the Middle East, in Europe, and now for the second time in Houston.
That's how we met with Marieke, actually, because I was in the Middle East as well. But tell us more about your background. Where did you grow up? Or which countries you traveled? What attracted you to international arbitration?
Well, which countries I've traveled? A lot of the countries in Europe. I think for me, the most important things that I did doing abroad was living and working abroad. So we lived we didn't meet in Qatar. We only met here in Houston, but you know how life is in Qatar, very international. And I was exposed by working there to a different court system and the world of arbitration. So actually, I started my career, of course, as a judge, was very focused on litigation, and that was for me the way to resolve a dispute. But by moving abroad, by living and working in Qatar and in Houston, I noticed like, okay, it's not ideal to have a cross-border dispute in court. So that was, I think, for me very important for my international career.
So why did you suggest this topic? Because Marieke suggested the topic of maritime arbitration. And as we're in Houston, it's very interesting for us, very important. But I wanted to ask why.
Yeah, well, a lot of reasons actually. But I think most importantly, maritime disputes are really take up a lot of cases. It's a large number of in the international commercial arbitrations caseload. So if you look at the cases that were handled by under the rules of the London Maritime Arbitrators Association last year, 1,800 of those. And that's twice the caseload of the ICC globally. And there are a lot of large arbitration institutions that have significant number of shipping and maritime disputes as well. So it's just an important part of our international commercial community caseload. So that's an important reason, but I also really like talking about maritime industry. And you said, you already mentioned I grew up close to the sea. I actually grew up very close to the port of Rotterdam at the time.
I saw the picture, very pretty picture of the sea.
I just love the water, and I grew up close to the port. At the time, it was the biggest port, still the largest port in the world. So in my environment, a lot of things happened close that were connected to the port. And now I live close to the port of Houston, which is the largest port of the US.
I grew up very far from the sea. So for me, the sea, it's more the pirates of Caribbean. So when I think about the maritime things, it's maritime battles or the pirates getting the ships. So tell us, what are the types of maritime disputes apart from this pirates
No
getting
pirates.
the
We have never dealt with pirates. I'm glad to say. So but maybe just to start with, so maritime disputes, that label covers a lot of disputes. So anything remotely related to a ship can fall under that label. And as a maritime judge in a court of Rotterdam, I handled a lot of maritime cases. So as a judge and as an arbitrator, I can walk you through the main type of disputes. So
Please go ahead.
Charter parties, I will tell you more about this, but that's about rental of a ship. Bill of lading, freight documents about cargo and cargo disputes, bunker oil, the oil that's the gasoline for a ship, let's just say so, shipbuilding, ship repair, ship purchase agreement, offshore and energy related projects that also falls under the maritime disputes often. Collisions and salvage. So when an
So they're arbitrable collisions.
No. So no, collisions and salvage and accidents in port and terminal operations, those things are, well, you don't have a contract for that. So those are the things that just accidentally happen. collision between ships, but also I've dealt with a case with a collision between a ship and a giant crane.
But not the pirate ship.
No, but so
Very
those accidents are not arbitrable. Usually you can always have a submission agreement, but usually you don't have that. And then you go to court. But for all the other disputes I mentioned, that's done through arbitration.
I see.
Often. Yeah.
Thank you so much, Marieke. But we will not have time today to speak about all these disputes. So we will ask Marieke to choose certain types of disputes that she prefers, if we can say so, and we will discuss this type. So what are your preferred types of disputes?
Yeah.
And why?
Okay. I have three. I like handling disputes in general, but I will focus on the three. So I will start with the charter parties because it's just the type of disputes that in the maritime arbitration scene you mostly come across. So you better just enjoy doing it. And so the charter party, that's a contract between a ship owner and a charterer that outlines the term for leasing a ship, and it sets out the responsibilities and the obligations of both sides, payment, so for hire of the ship or the payment for the freight, cargo, the duration. So anything that you could come across in a contract, but it's about the use of a ship. So
is it like renting a car, or it's more complicated?
You can compare it to that. And there maybe it's helpful to already mention that there are three types of charter parties. So you can have an idea what's happening there. So you have a voyage charter. That's, I think, the most simple form of charter parties, and it's a contract where in return for payment of freight, the owner of the ship agrees to perform one or more voyages and carry specified cargo. So that's a voyage charter. And then you have a time charter, and that is a charter contract in which, in exchange for the payment of hire, so that's a sort of lease hire, the ship is put under the orders of the charter. So the ship is still owned by the owner, and the owner has a crew and the master, but the charterer is actually in charge of what happens to the ship during that fixed period of time. And then you have a sort of sharing of costs. So, for example, cost of the crew and the cost of just running the ship and taking care of the ship, that's still for the owner of the ship. But if you talk about bunker oil, cargo handling and port charges, that's then for the charterer because he's using the ship for his commercial voyages.
And if you put it in the context of Houston, for instance, for LNG terminal, the LNG transportation, LNG is liquefied natural gas. Can the companies use any of these charters or all of them? How does that
I think in general you can use any kind of chartering agreement. And then I want to mention the third, because there's a third category, that's the bareboat. And then you actually just take over as a charterer everything. So you use the boat of the owner, but you put on your own crew and you are in charge like you are the owner. But I think what you usually, so if you look at disputes that we see at the Houston ports a lot, tanker disputes or tanker voyages, and that's often, I think, as a voyage charter, done as a voyage charter. Shall I go back to my favorite disputes?
Yes, please. I'm sorry. We got carried away.
Yeah, so much to talk about. So I think I just, of course, touch upon the charter
You
parties.
can go anywhere you want.
And but so my second type of disputes that I like are cargo disputes. Because shipping is all about, at the end, or mostly about getting cargo from A to B. That's at least what you think of when you talk about shipping. And usually it goes according to plan, but not always. And I like the types of cargo claims, different kinds of cargo claims, but I also like diving into a case and see, well, where did things go wrong? Whose responsibility is it? So that's what I like about the cargo claims. And then you have shipbuilding disputes, which I also really like. And I like construction disputes. I worked in Qatar, so I dealt with a lot of construction.
Especially you worked there before the World Cup, so there was so much construction
exactly
going on back then.
Yeah, so if you work in the Middle East, I think construction is really what you do a lot. And then shipbuilding is really a combination of construction practices, but then, yeah, of course, related to a ship. So it's high value, technically complicated, but still with some practices that I did and are relatable to the construction onshore.
And not to deter you from the topic, so any other favorite disputes?
Well, collisions are always interesting, but I only did that as
the
a
pirates,
judge.
right?
Yeah,
Collisions and the pirates.
yeah.
But we will not talk about it. Okay, well, so we will speak about charter party disputes, bills of ladings dispute, and shipbuilding disputes today. I personally don't know much about maritime arbitration, and I hope to get more knowledge here in Houston at some point. So, but I've heard about the standard charter party forms. Can you explain us what are these forms, when they're used, are they always used? So anything about charter party
Yeah.
forms.
And I think that's really interesting. Well, for me also, the maritime industry has so much different concepts that you usually don't see in the other industries. And of course, in different industries, you have template contracts, but you have so many template contracts in the maritime industry. And that's particularly when it comes to charter parties. And so these are contractual templates used to allocate risk and define key rights and obligations between ship owners and charterers. And they really play a central role in the maritime industry because they provide predictability, efficiency, and commercial certainty. And especially if there are so many transactions, it's really helpful to have a standard clause and the standard contracts. And those standard contracts, the charter forms, are developed by industry bodies, and they're then.
That's a question I wanted to ask. What are the bodies developing it? We know AIN, for instance, have the model contract for the host governments or other contracts. Who develops these charter party contracts?
So BIMCO is a very large, is the most important, I think, industry body, and that's I don't know what the abbreviation exactly is, but it's at least it makes sure that all the parties are part of the charter party industry are represented. So they are a sort of know-how, they make sure that the industry gets what they need. And that's especially when it comes to standard templates or standard contracts. And they make sure that they get input for contracts, but for charter parties from ship owners, from charterers, from ship brokers, from counsel, from insurers. So all parts of the contracts are being are consulted, and that's what makes the standard contracts also so balanced. They get input from technical operations, and what I really like about those standard contracts is that they are very balanced, and they're often used as is. So without
that's interesting. So people can just, even if they're not sophisticated parties, they can just take it.
Exactly. So I think in the maritime industry, you have a wide range of people who are dealing with contracts. And they can just pick a contract off the shelf that's helpful for them. And they don't have to amend anything necessarily, especially if then there's a contract that's really up to date. But if there's a contract that's a little bit older and then you can have more specified commercial additional supplemental agreement clauses, and you call these rider clauses. So in the shipping industry, if you have add-ons to your contract, you call those rider clauses.
Yeah. Do they have arbitration clauses in this model forms, or it's something the parties should add at some point?
I think there are always standard arbitration clauses, and that's also the reason why there's so many maritime disputes in arbitration, because all those template contracts, and there are maybe 20 or so available, or probably more, have arbitration as dispute resolution.
And what are the main arbitral institutions?
Yeah, I think it depends a little bit on the type of form. So ASPA that's a form that's often used also here in Houston. It's for tanker oil, and there was the form originally goes back to 1977, so 50 years, almost 50 years. But it
That's
was
impressive.
updated the last years, and a few weeks ago there was a whole launch of a new form. So you have now the Espetank Voy 2025, and there's the SMA. So in New York, the Society for Maritime Arbitrators in New York is the default, but you have then the option to choose the London Maritime Arbitration Association and Hong Kong and Singapore.
What about Houston Maritime Arbitration?
Yeah, it's okay.
They should lobby. They should lobby more.
I think it's good to have this webinar to at least mention the option, especially for Texas-based projects and deals.
Mhm.
I think the Houston Maritime Arbitrators Association rules are really helpful as well. And the HMAA, as abbreviation, was also set up to facilitate dispute resolution in this part of the world because there's so many projects, so many things going on, and it doesn't make sense to have a hearing in New York or London, and everything happens here. So that's also why, yeah.
And
they
Houston
were-
is at least
yeah.
as diverse as New York, right? So
Yeah.
we have all the lawyers we need to
Yeah.
Resolve maritime
Fully agree with
disputes.
that. Yeah.
Okay, then let's go back to our charter party disputes. What are the main sources of disagreement? What are the main problems arising in the charter party disputes?
Interesting question, Daria.
You're welcome.
So I think it's helpful to think again of the three types of charter parties that you have. So
Voyage.
Voyage. Yeah. So if you think of voyage, so one particular voyage, I think the number one dispute area there is issues about lay time and demurrage. So
lay time?
Yeah.
Okay, now you have to explain this.
Exactly. So that's for me, so I think interesting about the maritime industry. Again, so many different words that you otherwise don't use, but lay time is really the agreed time that a ship can use for loading and unloading in the port. So you usually agree on that, let's say 48 hours, depending of course on the size of the ship and the type of cargo they have, but let's say 48 hours you have for unloading or loading. That's the lay time. And if you have a delay for whatever reason, you usually have to pay a fee, and that's called a demurrage fee. And you can compare that with a liquidated damages clause. So it's just a fixed fee for any kind of delay. So if you have overtime with the ship, then you have demurrage fees, and that's really a big recurring type of dispute when it comes to voyage charters. And the time charters, that's when the ship owner still supplies the crew and the master, but the charterer is more in charge of where to go and what to do, what kind of cargo to have. And sums of hire are usually larger. So then you have disputes about the hire, if there's a late hire payment, withheld hire payments, deductions from hire for whatever reason. And the redelivery of the ship, because at some point in time the ship has to go back to the owner, and sometimes it's late or early because the charter is.
So the owner doesn't want to come early neither.
No, because they want to have the full time that they contracted usually, of course. So if they have a good contracting rate, they want to have, of course, the full time under hire. But that was the agreement, and sometimes you have a delay there, and then there was maybe another charter party that was waiting for that ship. So you have an issue when you return the ship, redeliver the ship too late. Too early would also be, of course, not in line with contract terms, because that would deduct the higher payment, at least that I think
now,
in the view of the charterer. Yeah.
Clearly from my head about this ship owner. Is it possible, for instance, the dispute when the ship owner has, I don't know, 2 places to keep the ship, right? Like 2 parking spaces. And then, but he has 3 or 4 ships, and the ship comes too early and he doesn't know where to put that ship. So he may have like hire another space to keep it. Have you ever seen something like that?
I haven't come across that, but of course it's a
practical issue. My imagination.
Yeah, but that's a practical issue. Usually it's being sorted, and there will be you can always usually find a space to anchor your ship, whatever, or to dock your ship. But of course, it does mean that that the contract terms are not complied with fully, and that's that can result in a dispute. So I think on the voyage charters, it's often about redelivery and then the higher of payment, and also about sometimes the shape of the condition of the bunkers in the ship. Is it good quality, and any kind of damages? Then of course you can also happen to get. And with the bareboat, that's the type of hire that really gets almost full control to the charter. Then you can get into maintenance issues, like who needs to pay what, and who has and there's an engine failure, who's responsible for what. Was the ship properly used, or was it unseaworthy? That's also an interesting, and that gets more technical often, more into the mechanics of a ship.
Without getting into any details or disclosing anything confidential, can you just bring us example of a case you had on a charter party dispute, or probably when you were a judge?
Yeah, and I think as a judge, I didn't see so many charter parties because they often went to arbitration. So what I've seen mostly is demurrage. So yeah, and it's like sometimes the reasonableness of the fee, because sometimes it can really get to a high amount, and sometimes it's really up to the port where the error is where the delay is, and sometimes also like really risk allocation. So I think it's really a commercial business, and you have commercial disputes.
Another question, a little bit unpredictable. What's the most used applicable law in these charter parties?
Yeah, good question. I think English law would be the most applicable law. And even if you have
even in Europe?
Yeah, even in Europe or Hong Kong, let's say you go for Hong Kong International Arbitration Center, English law is the most often the applicable law. So I was in Dubai a few weeks ago, and then the register from the Dubai International Arbitration Center said, well, we also have quite a number of arbitration and shipping disputes, but in 80% or so of their cases, English law is the applicable law. And I think that it really goes back to the history of London as really the most important center for maritime,
arbitration or deals?
Yeah, it starts, of course, with the commerce. So when really England dominated the world, they also dominated the shipping market, and all the contracts were entered into in London. You had the shipbrokers there, you had the insurance there. So everything, all the know-how really was in London, and also then the dispute resolution was naturally happening there. And that's, I think, still the basis for where we are now.
Have you ever seen a Texas law applicable in any of the maritime disputes?
Not yet.
Not yet. No. It's to come. It's to come.
And of course, there are disputes. And the LMAA caseload is definitely not as large as the London caseload, but there are, of course, cases happening.
English people are very, very good at marketing. That's something we know.
Yeah, exactly. Still, and they were
not as
100
good,
years ago.
but we are aspiring, right? So let's go to the second type of disputes, Bills of Ladings.
Yeah.
Okay, can you remind us what's that?
Yeah.
In short?
Yeah, it's a key document in the maritime industry, and it's issued by or on behalf of the carrier. So the entity that ships or is in charge of the ship. So we call that a carrier. And it has three functions. So first of all, it's about the receipt for the goods. So a shipper, let's say Target has wants to receive all kinds of cargo from China. That's an often a ship channel, and has purchased goods in China, and the company in China puts it on the ship, and that's the shipper. And then the carrier issues a bill of lading, and that a bill of lading confirms, first of all, yes, I have received the goods in a particular stated condition. So the bill of lading says in which condition and what quantity is of the cargo received. Then you have evidence of the contract of carriage. So it sets out the terms under which the carrier agrees to transport the cargo. It's a contractual document. and it is a document of title. And that's, I think, quite unique. So it allows the holder of the original bill of lading, not a copy, but original bill of lading, to claim the goods. So to get it, so let's say you have the shipping line from China and it arrives here in Houston, and you present your
So
bill
it's
of
a
lading.
paper. It's a paper.
It's a paper of value. Yeah, so it's a paper. Well, there's now all kinds of electronic bill of lading, but let's just say let's stick with the historical origin. It has been paper based for centuries. And then you present your original bill of lading, and then you can get your cargo from the carrier. But you can also sell your cargo while your container is in transit. So you can sell your cargo by handing over your bill of lading to the party you're selling your cargo to, and yeah, you can transfer ownership. So those are really the three most important reasons for bill of lading.
And what happens if you just lost that document?
Yeah, you have an issue. Yeah. Yeah, there are all kinds of theories to do that.
There are theories. There are solutions for that.
You can get around it, but it is an issue. Yeah.
I see.
Yeah. And there are also often multiple copies. So there's not necessarily one copy. It's sometimes duplicates because they're used for insurance, for financing purposes. So yeah. But the electronic bills of lading, we don't have to get into that now, but that's something.
That's very interesting.
Yeah, no, I will reserve that for another time. But
for another webinar on electronic bills of lading.
Yeah, we do so much online, and actually the electronic bills of lading are being used as well more and more, but it's been the shipping industry is in that sense has been holding on to the paper for a long time.
Tell us more about your experience with these disputes. Which kind of disputes did you have as a judge or as an arbitrator?
Yeah, it's a type of disputes I really like. So I spoke about the document of title. So of course you see disputes arising there because either somebody got the cargo without presenting the bills of lading, and then somebody showed up with the original. So you have a clash. Who was the owner?
How did they get it if they didn't present their?
Yeah, but sometimes it's like, oh, we have a fax, and because it's not always practical to wait. You have a carrier who wants to get rid of their cargo because every time the longer they hold on to their cargo, the more often they have to incur costs at the port. So sometimes they just rely on a document that's being presented to them, and it's not the original. So you have disputes there. But what I like most about the cargo disputes were really the cases about cargo.
Okay, tell us more about.
Yeah, there's cargo.
I feel excited. I'm getting excited.
Yeah, because as I said, sometimes just something happens with cargo, and I think I've done a lot of cases about food. So as a judge, I've done a lot of cases about food, and that's what I also like
because it's perishable.
Yeah, it's perishable. It happens. Usually, it's you can have the longest shipping routes and still receive your mangoes or your cheesecakes intact because you use reefer containers. That's a sort of cooling container. But sometimes something happens with your reefer container, or sometimes when the goods are dispatched from a warehouse, let's say go back to China, I had a case.
So we get fruit from China as well?
No, I had fish, a case about fish from China, and the packages were not stocked enough. Well, it was too fully stocked, so the cooling of the reefer container didn't work properly. So then the container arrived in England, and you have smelly fish. So that was one thing. And sometimes.
And what was the applicable law?
I think, I don't know. I can't remember that one because sometimes it's not English law and it's Dutch law. It depends also on the charter. Of course, they can say, oh, this is Dutch law. So in my case,
Dutch law is useful. Every law is useful. Yeah. Is often used as well. Not as often as English, but it's used.
Yeah, it can still be used because the port of Rotterdam is a very large port. It's still the biggest port in Europe, and a lot of commercial activities are happening there. A lot of cargo is going there. So you can still see Dutch law in contracts, and I did see that for cargo cases. But I can give you some more examples
Please go ahead.
of food where things went wrong. So I had a case about chocolate from Belgium.
Oh my God.
And octopus from Senegal.
Mhm.
So I told you about the fish from China and beef from Argentina.
That's very sad because Argentina
Yeah.
beef is really very
Yeah, and it's always a shame if you have, because it's a high value container, and then you have to throw it away at the end. That's
and
really
somebody
tough.
should pay, right? So
Yeah.
that they basically they try to decide to argue whose fault, whether it was packed badly or whether there were conditions.
Yeah, it's
such as that.
often once the container is received and something happens during that voyage, it's usually for the carrier. But then the carrier will say, oh, but yes, you didn't pack your container properly because this is not my fault. I provided you with proper functioning reefer containers. You had the issue. So that was, for example, that's a fish dispute I had. And I also had cheesecakes from United States. So what I think is interesting is
Going to the Netherlands?
Yes, yeah,
Okay.
exactly. So, but apart from the fact, so what happens, it's also interesting to see where we source our goods. So you see really well, cheesecakes, United States is has good cheesecakes. So yes, they are being shipped to the Netherlands. And then, and you see how connected we all are. So the whole, everything that people, yeah, could want to have can be shipped, and you see how connected we are through our ports.
That's impressive.
Yeah, so that's what I like about that type of disputes. Yeah,
because now we have planes, right? But a lot of companies still use the ships to transport.
And I think that's what people underestimate about shipping. Planes are very expensive, of course.
Oh.
So you do that with highly perishable stuff. So maybe, for example, for flowers from the Netherlands, you wouldn't put them on a ship. Only if it's a ship to England, for example. But so really valuable items or things that you really need quickly, you will put on an airplane. But everything else, you will put on a ship. And I think I've read somewhere 90% of our goods are being transported overseas. That's a large number.
Ships, yeah. We need to do the walk-in interview at the Port of Houston.
Yeah.
And show all our audience all that.
Yeah.
Okay, and now do you have any other comments on this Bills of Lading?
Yeah, what maybe is helpful to also know, because I spoke about the Bills of Lading as a sort of receipt for what you have, or it says something about the condition of the cargo that the carrier has received. And if you talk about a clean bill of lading, that's a bill of lading where it says that the cargo was received in apparent good order and condition. And you can have a dispute about, well, here you have a bill of lading that says, well, the cargo was in apparent good order and condition, and you open up your container with smelly fish. So where did what's then the value of the bill of lading? Do you really say, okay, you received it in proper condition, so anything that
the evidentiary value,
yeah,
right?
exactly. And I think that's also is quite interesting about this type of dispute. So I think what we do as arbitrators and judges, we do add value. We do treat the bill of lading as an important piece of evidence. So it's prima facie evidence that the cargo was indeed received in good order. But you also have to remember that you often only see the cargo from the outside. So you see it only in a package state, so you don't see it from the inside. So if anything has really been contaminated, for example, that there were bugs inside the packing, you can't see that as a carrier. So there's no value then for that kind of damage. But if there was damage on the outside, then you can still use evidence as to contradict your bill of lading. So then you get expert reports, a lot of survey reports, or the made receipts, loading records, witness statements. So everything to support the argument, like for the carrier, and like, okay, yes, I signed off on this bill of lading. but all the evidence that I have shows that something went wrong outside of my control. So that's I think an interesting part.
That's very interesting. That's very
Yeah.
interesting.
And you have to weigh, of course, what the probative value is and the reliability of the types of evidence.
Let's go to your third preferred dispute, which is shipbuilding.
Yeah.
So shipbuilding should be the most expensive type of things, right?
Yeah, and together with
High
offshore
value.
projects. Yeah, because offshore projects can be huge, of course, as well. But if I focus on shipbuilding, it's really a high value, often a high value project. So also high value disputes, because they involve long project timelines, they involve complex technical specifications and significant capital investment. And the financial stakes are substantial because vessels are expensive assets. They're often ordered years ahead, and because it takes a lot of time to build a ship, and you also have to have the capacity to build a ship. So you also have to just often wait for at a wharf to have the time slot to build a ship, and there are all these requirements that the ship has to comply with. So you have to, of course, classification standards. So to say, like, when it comes to environmental, for example, safety standards and regulatory standards. So there's a lot of things that a ship needs to comply with. And if anything goes wrong from a design perspective for construction quality or the timetable, that can result in high value disputes.
What's the applicable law? Is it also English law, even if the ship is being built in the US, or it's different?
I think that's a little bit more diverse. So if you really focus on charter parties, for example, then it's really English law. And still most maritime disputes choose English law because it has a really sophisticated body of case law, and people rely on that and feel like comfortable about applying English law. But of course, at the end, it's a matter of contracting. And if you have also standard forms for shipbuilding, but it's often more customized, and then you can, if it's
because you don't build ships every day.
No, exactly. And well, talking about shipbuilding here in the US, it's being promoted, but there's not much shipbuilding going on. Most of the shipbuilding goes on actually in Asia. So if you really talk about the cargo ships, the large vessels, but for example, the Netherlands also has quite a strong practice of shipbuilding. And a shipbuilder there would probably choose Dutch law.
Yes, makes sense.
Dutch law. Yeah.
What clauses most often create disputes for the shipbuilding?
Yeah. So I can walk you through them. So
please go ahead. Yes, because I'm really not familiar with all that. So anything you say, please go ahead.
So delivery dates and permissible delays. Of course, you have a contractual time deadline, and what's the delay? That's a big thing. Liquidated damages for delay and performance shortfall. Cancellation and termination rights. That's very painful for a wharf, of course. So if you have an order for a ship you're building and then halfway it gets terminated or canceled, the order, what to do with your ship. Change orders and variation procedures and warranties regarding quality and specification compliance. And I think the types of disputes that you often see is really about delays, if the delays were excusable, whether defects amount to non-conformity and justify rejection, and whether the buyer validly exercised the cancellation right.
So it's more like construction disputes.
It really is.
That really reminds me of problems that happen in construction disputes.
And I think that's is for me the attractive part of it, because you have I have the construction interest and experience, and I really like shipping.
You can use your construction experience in these types of disputes as well.
Yeah, and maybe I can give an example for that when we talk about delays, because it's really comparable to the approach you see in onshore construction disputes. So if it's about there's a delay, it's of course the main question is who bears the responsibility for that delay. And how
many parties do you normally have in this ship building of a ship? So can you walk us through how it happens normally? So there's a buyer, potential buyer. Does the buyer come and choose the ship like in a grocery shop, or it's really more like construction when the buyer comes and says, okay, I want to construct this specific ship, and then they go for the old
I don't
specifications.
I don't have the numbers for you, but you have off the shelf ships. But you can also think of that for just private use. So all the yachts that you see, like it's buying a car. It's like buying a car. You can buy a ship off the shelf, but it's usually like a car. You will customize it a little bit. You spend a lot of money, so you like to customize it a little bit. But the frame of a ship can be, or the shape of a ship, or the most of the parts of a ship can be standard with some upgrades. So that's a level that you have and that you will have in the larger transport carrier vessels as well. But I think a lot of lines will really have their own standard design. And you have also, of course, think of super yachts. That's often something that's highly customized for the very wealthy owner. So I think if you think of that, it's at the end, it's often a contract about a purchaser and a builder. Like with anything, when you purchase a house or buy a house, you have that with a contract with the builder and a purchaser, but there are a lot of parties involved, of course, for the financing, for the design, but that can be subcontracted as well.
Subcontract.
Yeah. So, but when I focus on delay issues, then you look at the contracts, because then the contract will set out often a clear mechanism for classifying delay. So what kind of delay are we talking about, and who bears the risk of that delay? And the builder generally bears the burden of proving that the delay is permissible. And it's permissible, for example, when there's force majeure or adverse weather within the contractual definition, or delays caused by the buyer's own acts, such as late approvals or design changes. And the buyer, on the other hand, will usually bears the burden of proof to show that it was the builder who was responsible for the delay, to justify the cancellation, the liquidated damages, or rejection or extension claims. And like in construction arbitration, you will need to answer the central question, like, but for this delay, but the delay would have occurred, but for the
For some actions.
Yeah, exactly. For the actions that are being put forward as something that was the shipbuilder's fault. And you have to look at, like construction disputes, you will have to look at project timelines, progress reports, inspection records, expert delay analysis, and emails. So it is really comparable.
Thank you, Marieke. Do you have anything to say about all these types of disputes, or I can go ahead and ask you other questions, more general?
Yeah. We have enough time.
Yes, we do have a little bit of time. I don't see any questions for now, so please don't hesitate to ask questions, or we will just keep going ahead. So, Marieke, I know that you're part of the Houston Maritime Arbitrators Association, right? And you're also aspiring to become a part of London Maritime Arbitration Association. So can you tell us more about these two organizations, why they're important? Do they do anything to promote maritime arbitration? Do they create contracts? Do they create arbitration, like model arbitration clauses? Like anything about the activities?
Well, I'll start with thanks for this question. It's always nice to talk about Houston. So I already mentioned a few things about Houston Maritime Arbitrators Association. Of course, it's really geared towards the Texas oil and gas, maritime and offshore markets. A lot of things are happening here. So it's really good to have.
I think people don't all often, especially people outside of Houston, they don't often understand how much how much happening in Houston, that we have something happening all the time, and even how have now this maritime arbitration.
Exactly. But we are the energy capital of the world, and a lot of things are done offshore as well. So that's maritime stuff. We have the largest port of United States, so all kinds of disputes arise there as well. So it's good to have a forum for that. And Houston HMAA, as we call it, is the only arbitration really set of rules here in Houston, in Texas, at least for maritime disputes. So, and it's good to note that we had rules that went back 2 decades or so, but they were updated and really had a good makeover, and they are effective 1st of January.
Right.
This
So have
in 2
new
weeks.
rules, in 2 weeks we'll have new rules.
Yeah, and they are really, I think, arbitration. Well, they include a lot of best practices. They were really good drafters of the rules. Really looked at what works well, what doesn't work. It's still, of course, it's some sort of U.S. based type of arbitration with some discovery, but with a lot of, I think, space for the arbitrator to customize it to the needs of the arbitration and to the parties, of course. And what I also really like about it is there's a emergency proceedings possible, which is in line with my Dutch
Yes, and
emergency
that's
oversight.
great.
Yeah,
That's great.
because you have a lot of urgent issues that can arise in
Mhm.
shipping. But I think that's good to note about the HMAA.
And
But-
what's can you compare with the London Maritime Arbitration
Yeah.
rules?
So both are ad hoc, so that's something that they have in common. So no institutional oversight, but both have quite, I think, involved boards. So if there's an issue when it comes to arbitrator appointments, at least the HMAA the board will be involved and also will appoint arbitrators if it's an emergency arbitration, of course. Or when parties are not able to select an arbitrator, then the board will be able to appoint an arbitrator under the rules. When it comes to London, yeah, I think it's a whole different rules even, because it's such a widely used type of rules under the LMAA rules. There's standard rules and there's expedited and intermediate
different
procedures.
types of
Yes. It depends on the value of the case, but let's just go for the standard terms because even in small value disputes they are often used and they're most widely used. So no institutional oversight, but very pragmatic. And everybody who is working in the, I think, maritime industry, especially based in London, knows how to use them. So you don't need a body of oversight. People know how to use them. You don't have to be a lawyer to use them.
So even smaller companies and less sophisticated users can just put this Houston Maritime Arbitration clause in their contract and then be sure that everything will go well.
And if you are not so experienced, then of course it's always helpful to have an expert. But if I look at the London market, then everybody who is involved in shipping knows, I think, its way with the London Maritime Arbitration rules. And I think what's also good to know, it's low cost, so no institutional cost, and you only pay an appointment fee for your arbitrator to be
How
able.
much is the appointment fee?
Yeah, £400.
So for London and for Houston,
no appointment fee.
No appointment fee.
No. So, but in London, it's what you often see is arbitration disputes get started. So, for example, I'm then approached by the claimant with the request: can you accept appointment in this particular dispute? And I then check conflicts and I can say, yes, I'm happy to be appointed. And then a notice of arbitration is sent to the other side. And the appointed party pays me an appointment fee. And for me, it is then waiting what the step will be from the respondent side. But what is different from institutional arbitration is institutional arbitrations usually, once the tribunal is in place, the dispute will move forward. But I am quite often appointed in cases that don't go anywhere. And then the notice of arbitration is really used as a sort of next step in the negotiation process to really show the other side we are serious about this claim. And we mean business, and we are willing to move this forward to an award, to a hearing, or in any case to a decision, unless you come to the negotiation table. So I think the numbers are essentially that about 50% of the cases that just get resolved after the notice of arbitration is sent. So I am appointment, but I don't have to do anything. And then in the remaining 50%, about half of those numbers are then resolved along the way. Then they might still exchange submissions, but they don't make it to an award.
I see that our time is coming to the end soon. We have 10 minutes left. So before I ask you my favorite question about the restaurants, I cannot just not ask about that. Can you tell us how you see Houston as a future center of maritime arbitration? Can we compete or not
Well,
yet?
I think we have to be realistic. We can't compete with London.
Not yet.
No,
Okay.
but I do think we can be very attractive for the US. And I think we have a lot of people
So we
here.
can compete with New York.
Yeah, I would say so.
Absolutely. We will do that. We will do that. And okay, my favorite question. So, what are your favorite places to bring your friends and clients for a dinner or lunch in Houston?
Yeah. Okay.
Do you have Dutch restaurants?
Maybe no, I don't think so. No, we are not really known for our cuisine. No, so I really like Mexican food. So I like anything.
And you're not alone.
No, everybody, I think you've had the discussions here before. Anything from food truck to fancy, but I won't, of course, take really business context to food trucks usually. So then you think of the fancy end and anything in between. But I think Jeanette already mentioned, but I really
Yes,
like.
Jeanette mentioned one very fancy Mexican.
So cheap. Do I pronounce it?
I don't know. I pronounce it Hochi, but maybe it's Sochi. We should. We will ask Jeanette next time.
In any case, I was really impressed by that restaurant in downtown Marriott Hotel. I can recommend that. And what I really like to do when I have people from other places here, friends, family, or just business connections, I like to take them to the Taste of Texas.
Taste of Texas.
Yeah, so the Texas is of course known for meat steaks, and that's a really nice restaurant. It has also a nice scenery. Is
it in downtown or is it?
It's at the Katy Freeway, I-10.
Katy Freeway.
Yeah. So yeah, nice to drive to, and it's a nice setting. You immediately feel like you're in Texas.
We should go there all together. With everybody who came to the webinars. I see we don't have questions, so we will maybe bring it to the end. Thank you, Marieke. It was very interesting to listen about maritime arbitration. I didn't know much, so for me, everything was so useful and new. I hope for our audience as well. So thank you very much to everybody. Thank you, Marieke, and we hope to see you soon.
Can I say thank you?
Yes, of course.
You are a great host. I really enjoyed your conversation. Yes,
and Marieke, as all others, will be soon on our podcast. Houston, we have a solution which you can find on both Spotify and Apple Podcasts. Thank you and talk to you soon.